that their own personnel can't use marijuana within 28 days of reporting for a shift, or in some cases not use it at all in their personal life. And we'll talk about the degree about how that's going to stand up to legal scrutiny in this controversial era. However, to get things going, we're going to get Naseem to start talking about immigration and how that works.
Thanks very much, Ryan. Good afternoon, everybody. Thank you for tuning in. So as Ryan said, today is the day marijuana becomes legal for recreational use in Canada, and many employers are scrambling to respond to the challenges this important change will create for their business. An issue that may have been overlooked or understated is how this issue will be dealt with at the border. Notwithstanding the legalization of marijuana, there will be a strict legal framework for controlling the possession of cannabis in Canada. Taking cannabis across the border into or out of Canada without a permit or exemption authorized by Health Canada will remain a serious criminal offense subject to arrest and prosecution. So one of the big questions is, can business visitors bring marijuana into Canada if they have a doctor's prescription or marijuana is legal for recreational use in their state? The answer to that question is absolutely not, unless the person importing the marijuana has been issued an exemption by Health Canada to import marijuana for medical or scientific purposes. The process for obtaining an exemption from Health Canada is very complicated and time-consuming. It is not likely that many business travelers would be prepared to invest the time and effort to obtain such an exemption. Therefore, it stands now visitors to Canada will not be able to import marijuana to the country regardless of the legal status of the substance in their home jurisdiction. One of the big causes for consternation and concern is, can business travelers bring marijuana into the United States or other countries? Business visitors cannot export marijuana from Canada into the United States or any other country. Regardless of the status of marijuana in other countries, it remains an offense under Canadian law to export marijuana out of the country. Marijuana remains illegal under federal law of the United States, and that encompasses immigration law and most other countries. Those caught importing marijuana into those jurisdictions can face severe criminal penalties. Can a person be barred from the United States for using recreational or medical marijuana in Canada? We do not practice American law and thus cannot answer this question definitively. However, in consultation with our colleagues in American jurisdictions in the Work Law Network, it has been stated that any visitor to the United States who is a drug abuser or addict, or has been convicted or has admitted to the commission of a violation of marijuana laws will likely not be admitted to the United States. Now, some clarification on that occurred last week when American authorities publicly stated that a Canadian working in the marijuana industry in Canada will generally be admissible to the United States provided they are not visiting for a reason related to the marijuana industry. So if a business visitor is found to be coming to the United States for a purpose related to the marijuana industry, they may be denied entry. For those business visitors to the United States that need more detailed guidance on this issue, we'd be happy to refer you to an immigration attorney in the Work Law Network. So one of the burning questions at the end is, will border laws on marijuana for business visitors ever be liberalized? We don't have a crystal ball, and thus you should take our comments with a grain of salt. However, it does appear the United States is gradually moving towards a more tolerant attitude towards marijuana, and it is at least possible that it will eventually be legalized at the federal level. If that is the case, it is possible that some limited imports and exports for personal use will be permitted in a similar manner to personal use duty-free exemptions which currently apply for alcohol. And one final note, and that is that for those who have been convicted of marijuana offenses in Canada, the new legislation is going to change how that is viewed in Canada. Ryan's going to get into more details. And also there was a news item, I believe it was yesterday, that talked about the fact that the government was going to be releasing some guidelines on pardons for Canadians who have criminal convictions for relatively small amounts of marijuana. keep in mind that those pardons, there's a very strong likelihood that those Canadian pardons are not going to be recognized by the US Border Patrol, and thus simply getting a pardon is not going to mean that you're magically admissible to the United States. Thanks a lot.
Thanks, Naseem. I think that you know, that's a great jumping off point for our discussion today, because it you know, a lot of the sort of knock-on effects that Naseem spoke about really do speak to a lot of the issues that employers are going to face. It's not the legalization of cannabis per se that we're looking to respond to. It's all of the potential knock-on effects in the workplace. And so to sort of set the stage for what those knock-on effects may be, I'm going to speak very briefly about how Ontario has taken the Ontarian legislative approach to regulating this newly legalized substance. Obviously, and we've got listeners from across the country on today, these laws will be different from province to province, but thematically, most of the legislation that we've seen is fairly consistent, although of course, prior to taking any action, you're going to want to make sure that that the laws in the province in which you're operating, or where that action is going to be taken, are going to reflect the particular nuances of that legal regime. So in Ontario, the provincial approach has been mostly mandated through a piece of legislation called the Cannabis, Smoke-Free Ontario and Road Safety Statute Law Amendment Act. This is a piece of legislation that both introduces a couple of new bills as well as amends some existing bills to account for the legalization of cannabis. And the primary mechanism it uses is the creation of a brand new act called the Cannabis Act, which, not surprisingly, comes into force today. So this is now the law governing Ontario. This extensively regulates cannabis use, possession, and sale within the province of Ontario. There are also, but it should be noted, and this is a theme that's going to come up, I think, throughout this webinar, we're focused on recreational marijuana. The regime that exists for medical marijuana has not significantly changed because of this, because of the legalization of recreational marijuana. There are different factors at play when you're dealing with a medical marijuana or cannabis issue as opposed to recreational use. So keep that in mind throughout. We'll touch on some of the differences. But when we're talking about legalization, we're primarily focused on recreational use of cannabis. The Cannabis Act says that retail can only occur through government authorities, and that if there are unauthorized sales taking place in the premises of some other facility, then the police can actually shut that down, very similar to how law enforcement has the ability to shut down premises where under other regulatory regimes where unlawful conduct may be taking place. The Cannabis Act bars possession or sale of recreational cannabis to anyone under the age of 19. So some employers with younger workforces will want to note that. One of the major prohibitions in the Cannabis Act is certain bars on where cannabis can be consumed or possessed. In particular, the Cannabis Act precludes consumption in public places, and now public places is not defined, so that could obviously capture a broad range of places, but also no consumption in workplaces, and that's as defined under the Occupational Health and Safety Act. So that's obviously going to be something that's going to be of major importance to employers. I would also note, and this is not directly a cannabis, not directly related to the legalization of cannabis, but that currently there is a case that is scheduled to be heard by the Supreme Court in December, which should give us a lot of guidance as to how broad or narrow a workplace is under health and safety legislation. And so consequently, again, that knock-on effect, that could impact where consumption under the Cannabis Act is prohibited, and also no consumption in vehicles or boats. And far from just being consumption, that bar on cannabis use in vehicle or boats actually extends to prohibit possession in vehicle and boats, except if the cannabis is either packaged or stored in such a way so that it's not readily available to any occupant in the vehicle. So this is a really big, broad prohibition on the way in which cannabis can be possessed. And of course, if you're an employer where your employees either use personal vehicles for work or use company vehicles for work, that's something that you're going to want to note. So those are the main thrusts of the provincial legislation at a high level here. But it's not just the provincial legislation that's being changed, it's also the criminal code. And Ryan will speak a little bit to how that is going to play out and the impacts we might see when it comes to workplace and workplace management.
Well, it's been a long time since the government passed the Criminal Lawyers Full Employment Act, but that's where marijuana is going to be. It'll be a golden age for litigation in the criminal courts, as I think you're about to see. In terms of just, I think it's important that people just sort of understand what the criminal framework of this is. Police must have reasonable grounds to suspect drug use if they're stopping someone before proceeding with any drug testing activity. I note this is a difference that reasonable suspicion has been removed in terms of alcohol relatively recently, so police now have the power basically just to test anybody for alcohol use, but that's not the case with drug testing. It's my view that there's going to be almost an unfathomable amount of litigation dealing with this issue in drugs. I mean, there are literally thousands and thousands of reported cases dealing with impaired driving. They are by far the most litigated criminal issue in Canada, taking up literally 3/4 of provincial court time in this province, according to Ministry of Justice statistics. So it's an interesting, so obviously this will be opening up a new web. Ultimately, in terms of what the police can do to determine whether someone is impaired for drugs, one is the standard age-old roadside field sobriety test, which I mean, if any of you have ever watched American television, you'll be familiar with this, but it's certainly something that is as older than the breathalyzer, but ultimately the kind of activities that one deals with in a roadside sobriety test is determining if a driver's eyes involuntarily jerk while following an object, determining whether a driver can walk 9 head to heel to toe steps while counting them and then turn, evaluate if a driver can stand on one leg and count to 30. I mean, that's by no means a full list of the kind of activities, but ultimately police use these standard activities to evaluate whether someone is impaired by a drug. And then ultimately, if the driver fails, the police officer will be qualified as a quote-unquote drug recognition expert, which one should not assume that takes a huge amount of training in order to do so, but they would be qualified as an expert and then testify to their opinion the person was impaired, and then the trial would proceed from there. Certainly, but ultimately, the reality is, though, that the federal government has implemented a test that they say that is much like the 0.08 or 0.05 under provincial legislation for driving that is out there. This particular test is very controversial. There was a Norway study that said that the test the feds have used for the criminal code did not absolutely correctly identify those driving under the drugs. There's lots of false positive or false negative results compared to drug concentrations in blood. One can assume if one makes one's living as a drug expert in this area, you will probably make a good living for the next couple of years doing nothing more than testifying in court about challenging the drug testing regime. There's also a serious concern about the reliability of the test in the Canadian winter. There's some suggestion by critics of the test that where the temperature drops below 4 degrees Celsius, that the test isn't reliable. All of this is important, of course, for us in the employment context, as we're realizing even in the criminal world that testing, which is a whole other and rather controversial situation, for employers that we can see from the criminal context, much remains to be determined about the validity of the test. And obviously, we don't have the benefit of significant international experience because, of course, we're kind of a pioneer, as we mentioned at the outset on this issue. We anticipate there's going to be considerable scientific and political debate about whether these tests are reliable and whether they're not. And it'll be years. I mean, ultimately, one will expect that these tests will ultimately come before the Supreme Court of Canada, probably in the criminal context, for some comment. But just to give you sort of a framework of how this works in criminal law as it stands, there is a saliva test. That what happens is that where a police officer has grounds to believe that a person is on drugs, be it with the smell of marijuana or slurred interference with speech or bloodshot eyes, those kind of things. The person that if the basically that they all the saliva test can do is check for the presence of marijuana, and if the person fails the saliva test, which is set at the numbers set out on the slide, then a blood test is taken of that person to confirm whether or not they're over the limit of these amounts. I mean, again, there is a significant dispute in the scientific community about the merits of these particular limits as they're set out. I mean, I've been reading a lot of it and I find it fascinating. I don't think it's probably useful to go through that particular exercise today, other than to say there are some that say that these amounts are random, that for some people who are regular users of marijuana, that it doesn't have an impact. So it's all, I mean, this is probably by far the most practical difficulty in dealing with marijuana, is the science is not caught up to the law. One would presume, given the amount of money at stake, that some company will eventually have a more definitive answer to these questions, given that eventually I would assume that every police force in the Western world will eventually want one of these things, assuming that the rest of the world follows our lead and legalizes marijuana, which of course remains to be seen. So that's sort of the criminal law background as to where we're headed. Frank's going to come in and talk to you a little bit about where we are as marijuana as a human rights ground.
And I think that this is clarity on this subject is really important. There's been a whole lot. This is where we see a lot of questions and confusion, which is when does cannabis, marijuana use, is it something that upon which human rights even applies? Just as a very clear baseline statement, the recreational use of cannabis is not per se protected by the Human Rights Code. Notice I qualified that by saying recreational, and notice how I said that per se, because there are some situations in which cannabis use can trigger aspects of the Human Rights Code. And as employers, we're going to want to be alive to the potential for those situations and ensuring that and we'll talk about later about how to monitor and control cannabis use by the workforce to ensure that that approach does not throw the baby out with the bathwater and capture these situations where a more nuanced and human rights approach is required. And there's three primary ways in which cannabis use can engage the Human Rights Code. The first of these is medical marijuana, and this is something that many employers are already familiar with. There has been a regime in place to deal with medical marijuana for the better part of 2 decades now in Canada. We'll talk a little bit about that. The second, which is something that has sort of existed as a potential issue, but which has not been litigated to this point, at least not any reported decisions, is the question of cannabis addiction. So where recreational use goes from being a preference of a particular individual to being something that is a physical addiction that they're compelled to do, and that can engage the Human Rights Code in the same way that other addictions can engage the Human Rights Code. And then finally, and this is sort of an 11th minute question, because the federal government just came out late last night to state that it had some preliminary discussions on providing pardons to for offenses where you're talking about simple possession of cannabis under 30 grams. And this is something that many employers may not know, that situation could also engage the Human Rights Code, and we'll talk a little bit about that as well. So the first and most straightforward situation where cannabis use can be a human rights ground is where cannabis is used medicinally. If cannabis is used to treat a disability under the Human Rights Code and is required to treat that disability, then the Human Rights Code is going to be engaged, and that use is going to have to be protected and accommodated to the point of undue hardship. Of course, there's specific concerns with medical cannabis use that we may not see with other disabilities, right? The use on site, the effect on others. There's, unlike a prescription drug where, it may have some intoxicating effects. An employee can take that over their lunch or, take a 5-minute break on shift. That's not a problem. But the actual consumption of the medical marijuana obviously can be a problem. And of course, the health and safety concerns. And this is probably the #1 concern that we hear employers express about medical marijuana. And that's that I have this person who's taking this. We know that it can have an impact. How can we have this person operating heavy machinery, driving a company vehicle? How can we rely on them? So the first question when you're faced with a medical marijuana use question or request for accommodation is, what does the employee need? What do they need in terms of times in which they consume the medication? What do they need in terms of the dosage, and how can that impact their ability to fulfill their duties? Remembering, of course, that employees are entitled to reasonable accommodation, not the accommodation they want. So it's imperative that if you have a question, if you have an accommodation request for medical marijuana, at a minimum, you want to have the medical information of what's that consumption going to look like in terms of timing, as well as how is it going to impact the employee's ability to work. The consumption of medical marijuana may be policed. So you can create a schedule whereby breaks are given in such a way so that the person can consume the medication in accordance with their restrictions. There's going to be some flexibility so long as that person is entitled to take the medication pursuant to their doctor's schedule. I always refer to this case, Francisco in Ontario, which is a case from several years ago, but in which an applicant at the Human Rights Tribunal asked to be allowed to smoke medical marijuana in the hearing itself. And I thought it was a really interesting case because the Human Rights Tribunal said there was no issue taken that this was medical use. There was no issue taken that he had to consume it on a schedule. But the tribunal said, we don't want to let you smoke in here, but we'll take breaks to allow you to leave the site so you can go outside and consume it. And that's the sort of analysis that you're going to need to undertake. You're going to want to get that medical information from a doctor directly, much the same way as you would with any other sort of disability situation. And of course, especially when we're talking about the potential impairing effects of a medical cannabis use, the Occupational Health and Safety Act gets engaged. If we're talking about the creation of a risk in the workplace because of medical marijuana use. So if we're talking about somebody who's operating heavy equipment, who is in a safety sensitive workplace or position, and they're going to be potentially subject to using medical cannabis, and that's that dosage is enough that they could be impaired, then if a health and safety, if their continued performance of their duties in that position will put the safety of themselves or others at risk, then you're likely looking at something that could very well constitute undue hardship. Keep in mind that may mean that even though the employee can't be accommodated in that position, if they can be shifted to other, perhaps non-safety sensitive duties, that may be part of the duty to accommodate as well. But there is room within the Human Rights Code to address the serious potential health and safety concerns described or that employers have with respect to this use. That also applies when you're driving company vehicles. I mentioned earlier the Cannabis Act. Ryan mentioned the crackdown on drug impaired driving, but also the Cannabis Act with its specific rules on possession, on consumption within vehicles. That's something that you're going to want to monitor to ensure that you're not having your workers do anything on shift that could lead to a regulatory or criminal breach. As I mentioned, any duty to accommodate the use of medical cannabis is going to be subject to the undue hardship standard, but that's a high standard, right? You can consider serious financial burden, although that's often a tough case to make, health and safety risk, and impact on the viability of the operation. Those are sort of the most common ways in which we see the undue hardship threshold met. But inconvenience to business, customers, or staff, even customer complaints are likely not going to be sufficient in the vast majority of cases to trigger an undue hardship such that the employer does not have to actively accommodate the employee. There's one case that I think it's valuable to review at this point, and that's a case from Newfoundland and Labrador. This case, and the employee's name was Tizard, which, given the length of the parties, is usually the way that this case is referred to. This case involves a worker who suffered from a pain disability and took medical marijuana. There was no dispute that the employee was disabled or that the marijuana was taken appropriately as a treatment for this condition. Now, this employee asked for 2 job postings, and this is in the context of the construction of a hydroelectric dam. Both of those, he was denied both of those job posting applications on the basis of his medical marijuana use. And what the employer said was, look, these postings are for their construction postings. You're going to be working very close to large pieces of equipment. You're going to be in demanding field and weather conditions. There's going to be very limited ability for first responders to attend at the workplace. If something goes wrong, this is a very, very safety sensitive workplace. And the problem that we have is we know that you're taking this medical cannabis, but we can never know, are you going to be at 100% for a shift? We're not going to be able to mitigate that risk. And the arbitrator agreed with the employer on this. One of the interesting things is the arbitrator took the tack that even though there was no doubt that the employee was, there was no dispute, it wasn't alleged that the employee was likely to abuse this to consume recreational marijuana or anything like that. But there's a significant problem in that there is no way to test whether at any given point he was impaired. His judgment was impaired. He could present a health and safety risk. And residual impairment was possible, right? This is a situation where the employee, even on his best efforts, could not necessarily guarantee that there would not be impairment, that there would not create this associated health and safety risk. And so, given the extreme safety sensitive nature of the workplace, the arbitrator said, look, you're creating an irremediable safety hazard. This is not something that can be controlled, and it could have very significant consequences. This is undue hardship because we can't eliminate this particular risk. And so these job postings are just not appropriate, and the employer was within its rights to say, unfortunately, you can't meet the requirements of this position, and it can't be modified because of this irremediable safety hazard. So that's medical. That's the medical side of things, and that we're still seeing evolving case law there, but that's more tangentially impacted by the events of today. Where we may see a lot more implication of the human rights grounds is in the question of cannabis addiction. Now, addiction, as many on this webinar will be aware, is considered a disability under the human rights codes of all provinces in the federal government. And addiction is traditionally described and judicially defined as a disease characterized by impaired control over the use of an addictive substance despite adverse physical, psychological, or social consequences. It is certainly possible that cannabis addiction could constitute a disability under the Human Rights Code. Now, I'm going to pause here to say it doesn't actually appear that this has ever been adjudicated. There have been a number of cases where human rights complainants have actually gone out of their way to say, no, I'm not suffering from an addiction to marijuana. The point of the addiction, this is not a recreational choice. This is not what you could call a lifestyle choice. This is simply a compulsion to consume cannabis or any other drug that the person cannot control. So this is something to watch out for. That's and obviously, as one can presume that as legalization becomes more mainstream, we may see claims of cannabis addiction. Now, so that's the added hurdle for employers. The good news is that there's already a well-established framework for dealing with addiction for employees. We've seen this engaged in terms of alcohol abuse, prescription drug addiction, all of these sorts of things. And there's no fundamental difference when we're talking about cannabis as opposed to alcohol addiction, as opposed to prescription drug medication, prescription drug addiction rather. How do employers deal with this? Reporting mechanisms, right? Making an environment where employees are required to bring forward, if you're battling an addiction issue, the employer is going to support you, but we're going to have to work through that process together. One case that we refer to often is a Supreme Court case a couple of years ago called Elk Valley, which involved an employee who, after a workplace accident, was tested for intoxicating substances and tested positive for cocaine, and then immediately in defense to that, he stated he was suffering from an addiction. The employer nonetheless terminated his employment. This went up to the Supreme Court, and the Supreme Court said the problem here is not the addiction. The problem here is that you did not report that you had been experiencing the addiction. You had breached the policy, and by breaching the policy, you created a serious health and safety risk. And so it's important that that expectation that an addiction be disclosed and that it will be kept in confidence, it will be treated by the employer under the Human Rights Code, be communicated to employees so that you avoid these problems where you have late disclosure, because that really puts the employer in a difficult position. I should also note that the non-disclosure, or that the disclosure requirement cannot be absolute, because in many cases, addiction, one of the manifestations of addiction is a denial of the addiction. But that mechanism should be in place. You should be prepared to act on it. If you do have a report of an addiction or it comes to your attention, we see last chance agreements all the time where employees remain working, but agree that they will be subject to attending, support meetings, to attending counseling that can be monitored by, that their attendance with can be monitored by the employer. They may also be subject to random testing. The employee can agree to that. Discussion with doctors is essential as you're dealing with any disability, finding out what those functional restrictions are. And of course, if you do have somebody who is staying in the workplace while they're dealing with an addiction issue, it may be necessary to remove them from problematic duties such as safety sensitive duties until the issue is under control. And that goes back to the creation of that health and safety risk. But this is going to be a highly fact-specific situation. You're going to want to carefully consider the individual employee's situation in that. So we've dealt with medical marijuana use. We've dealt with the addiction issue. One final, and this is a more minor note, but something that arises out of yesterday's announcement about the plans for federal level pardons of some possession offenses. It's important to note that under the Ontario Human Rights Code, record of offenses is an enumerated ground, and what that means is that employees cannot experience differential treatment on the basis of their quote-unquote record of offenses. And a record of offenses includes pardoned criminal offenses, unpardoned criminal offenses, but it does include pardoned criminal offenses. So if you become aware of an employee or a potential candidate for employment, and they have a conviction that a pardoned conviction for any crime, but especially these new these simple possession pardons, you're going to want to be very careful that you ensure that that knowledge does not influence your decision-making process. And if you do see, if you have, perhaps you're a workplace where you employ things like criminal records checks, if one of those sort of low-level, simple possession of marijuana under 30 grams, if that comes up, it's likely worthwhile to inquire to make sure that this is not an offense that was pardoned, because if it is, then you're going to run into these situations, and always best to err on the side of caution. So that's the human rights. We've sort of talked about the legal framework leading up to this point, but the real question that most of our clients are asking us is, how do we approach this situation? How do we ensure that we maintain our workplace as an efficient and safe place to work, while still making sure that we respect the new cannabis regime? And so now Ryan's going to speak a little bit about an approach that some employers have taken that has been in the news recently, where we see blanket bans implemented and what the legal implications of that might be.
All right, thanks, Frank. So we're heading into, we've seen that those of us who are following the headlines have been seeing that there's been a rash of announcements, primarily from the law enforcement and aviation communities, which have implemented policies which essentially ban the personal use of marijuana by employees per se, or such policies as an employee can't smoke marijuana within 28 days of reporting for work, which, unless you get far more vacation than I do, pretty much amounts to the same thing. I'm not too many people that are off work for more than 4 weeks while they're regularly employed. So what does that what does that mean? What do we is this actually enforceable? Certainly, employers out there that are veterans of the battle over drug testing can certainly appreciate that there's going to be a number of challenges to this. The type of organizations that have implemented these policies are largely unionized, so that allows for a fairly straightforward policy grievance to challenge it in most cases. Our view is that these policies are a reaction to the significant limitations on random drug testing. Notwithstanding the fact that I had reviewed with you before, that the criminal law sets out drug testing to which someone could ultimately result in going to jail if they were subject to the maximum penalties. The courts and arbitrators as it stands now have made it very difficult for random drug testing. I mean, the TTC is one obvious exception, who were able to demonstrate a significant past problem in the workplace at the injunction level, and that dispute is ongoing. But generally speaking, random drug testing is a no-go in Canada as it stands now, even for safety-sensitive positions. And certainly some of these employers might be reacting, well, if that's the case, then forget it. This is the safest thing to do, is just to say, you want to work for us, then you're not smoking pot, or you're not smoking pot within a number of weeks of showing up to what are all obviously largely extremely safety sensitive positions, pilots, police officers, and the like. It's important to appreciate, though, that these employers, when they're unionized, are going to have to prove that the employer rule is reasonable, set out in the well-known case of KVP, which has governed this for decades in this country. And there's no question that there's going to be a very viable argument that it is not reasonable to severely ban an employee's use of a legal substance. Obviously, there's no case law on this, because before marijuana was illegal, so of course it was a straightforward ban was imposed by the law. But there's no doubt that we can anticipate that the unions could make an argument that this is unreasonable. We've seen some alternative approaches to this. The Montreal Police, for example, have a fit for duty policy, which ultimately means one will show up if one is in non-intoxicated condition. If there are signs of intoxication, you proceed from there. If I were to put on my crystal ball and guess where this is going to end up, I don't think that these strict marijuana policies are going to be enforced by arbitrators. They may very well be. Some have suggested they may very well be. So it's a way to sort of encourage a discussion of the issue, that perhaps collective bargaining can deal with some sort of drug testing regime, or employers could be sufficed with the current drug testing regime, which generally permits drug testing after a serious incident or someone showing significant signs of impairment, or whether there's an agreement in certain circumstances. They'll also likely point out that it's a criminal offense to be impaired and drive, which would cover police officers and pilots most of the time. Employers, of course, are going to respond, well, look, we have a general duty. There's a general duty clause under OHS legislation. Right now, there's nothing in any Canadian OHS legislation that deals with drug testing or with marijuana, but there is an obligation under the Act, which in Ontario is found in Section 25 sub 2H, and every other piece of health and safety legislation, including the Canada Labour Code, includes a similar provision, which says the employer is required to take all precautions reasonable in the circumstances for the protection of a worker, which one would assume would certainly require a robust marijuana use policy, and especially dealing with safety-sensitive employees. I think it's probably fair to say that it doesn't go as far as random drug testing. The law doesn't seem to permit that, but certainly it gives that if there is an accident that takes place at work and marijuana is a factor, and an employer's lack of policies for dealing with that can be dealt with under that general duty clause, in my view. And also, employers are going to defend these policies are simply going to point out these are very safety-sensitive positions. The law is not letting us do random drug testing in most circumstances, or not without a Goliath of a legal fight. So that if that's the case, then we have to resort to what some might see as more draconian measures. Ultimately, this may be an issue that's addressed in future negotiations. We can't forget that the Supreme Court of Canada, in the Irving decision, came down fairly heavily on the side of employee privacy in testing cases. That was dealing with alcohol in an objectively serious safety environment in the context of a paper mill, and that case wouldn't allow random testing to take place. So again, it's ultimately, we have to recognize the courts, as it stands now, have taken a pretty firm line on employee privacy on this issue. Whether the legalization of marijuana will finally be the impetus for some, perhaps from an employer perspective, more progressive approach to this issue remains to be seen. If you want our 2 cents on this, I think it's incumbent upon the Ministry of Labour in Ontario and the various labour OHS enforcers across the country to address this issue head on, to simply spell out what an employer's obligations and what an employer's rights are. Ultimately, it's my view that the Occupational Health and Safety Act should be amended to specifically set out that random drug testing is permitted in a safety-sensitive position, and should overturn this judge-made law that's imposed limitations on an employer's ability. And if such a regime is in place, that would presumably eliminate, or certainly significantly mitigate, the need for the more draconian, perhaps not legally sustainable approach that's been taken in other contexts. I've spoken a lot about unionized employers, and they're sort of at the forefront of all this, but one must remember that if you were trying to implement a random testing program, or trying to terminate someone for off-duty use of marijuana, the case law has always been around firing employees for off-duty conduct. It's got to be relevant to the job. For example, a teacher arrested for possession of child pornography would be an example of something where, even if it wasn't at work, that would sustain, presumably, and generally has sustained, a just cause finding by an arbitrator or a court. But in this context, if you're going to terminate someone for off-duty use of marijuana, you're going to have to prove it affects work, which means I think, short of certain very specific situations, perhaps a church or a Christian school or religious school that opposes the use of marijuana on moral grounds and religious grounds, you're going to be hard pressed to say that someone can't use a legal substance in their off time and have that impact your community. and firing that employee, that's something you'd want to get some legal advice on. So I'm telling you, you're unlike in the United States, where I think it's important, especially for those of you who report to American companies. American courts have a much wider tolerance than Canadians do of allowing an employer to regulate essentially an employee's off-duty conduct. Drug testing of employees, even in non-safety sensitive positions, is routine in the US. Largely, of course, remembering because drugs are illegal, all of them. And people being fired for them is not a controversial prospect in most places in the United States. We diverge radically on this issue. And speaking to American employment lawyers through our Work Law Network, which we are members of an organization that deals with US lawyers in almost every jurisdiction, every time we talk about sort of this whole drug testing and termination for drugs issue. I mean, it's like, the US is from Mars and Canada's from Venus. I tell you, it's two radically different places. So when you're explaining this to your American colleagues, I'm sure they're used to things being different in Canada. This is really, really different. I'm going to turn it back over to Frank. He's just going to we've alluded to drug testing, and we don't, purport to want to cover it extensively, but he's going to give you a bit of an overview as to where the law is on that issue as it stands.
And so just very briefly, and I won't take very much of your time. I mean, we've spoken at length about many of the decisions, Irving, Pulp and Paper being the leading one. But it's relevant to go over quickly now, so that employers understand what they may or may not wish to try to implement. In general, as Ryan alluded to, random drug testing is off the table. There does exist a very narrow window within which, particularly in a unionized workplace, random drug testing can be implemented. But by and large, unless you fall into a very, very small subset of particularly safety-sensitive workplaces, and even then only under certain conditions, generalized random testing is not usually something that will be upheld by an adjudicator. Generally, employers are entitled to test employees in safety-sensitive positions where there's reasonable grounds to believe that the employee is impaired on the job, and this is usually going to be something that's a visual observation. There are certain physical manifestations that drug or alcohol use can have, and of course, one of the things that makes things simpler, if you're looking to implement this in respect of marijuana, is the fact that those manifestations are much well known than perhaps the abuse of certain other substances such as prescription drugs. Reasonable grounds can also consist of a workplace accident or a high-risk near miss. Or as I mentioned earlier when we were talking about addiction, where we have a situation where an employee is returning to work or is continuing to work while they are dealing with an addiction issue. So in all of those cases, there's that reasonable grounds threshold is usually met. Of course, as I mentioned, a lot of the litigation over this has been from unionized workplaces where it has been almost universally these policies have come across hostile audiences in judges and arbitrators. So that's the framework. We've talked a little bit about the considerations, the legal considerations, and some of the approaches taken to address this, particularly in certain particularly sensitive workplaces. How do we as employers, how do we try to deal with this? How do we come up with mechanisms to control our workplace, control what we see as potential negative impacts arising from the legalization of recreational cannabis, while still ensuring that we maintain that we are legal, that we're consistent with the legislation, and that any actions that we take under that approach are going to be ultimately endorsed by an adjudicator. The usual approach is simply we're going to create a cannabis policy. Well, that's easy, right? No problem, we'll do that. Well, no, it's a more complex situation than that, because when you're dealing with a cannabis policy, it's going to be very important to to create a policy that is responsive to your particular workplace. Throughout this, you've heard safety sensitive workplaces or other workplaces, all sorts of qualifiers. That's really the first step in coming up with an approach to deal with legalized cannabis, is to identify what are the potential negative impacts we are concerned about. And I've listed on the screen, you can see some of the most common concerns that we hear about from employers when it comes to the impacts of legalization. Health and safety is the overriding concern, especially in safety sensitive workplaces. But don't forget, even in a non-safety sensitive workplace, you may be looking at situations where employees are driving or commuting from time to time, and this can be a concern as well. Productivity is another obvious big concern. I also hear a fair amount from our clients about concerns with culture, image, and morale, right? And that's going to come from both inside the organization, where there may be a perception that employees are, employees who are using marijuana recreationally aren't being as productive. And it can also come from customers who don't perceive this as being a very professional sort of thing. And of course, the concerns with possession and sale contrary to the Cannabis Act, which, if some of those violations of the Cannabis Act occur during working times, then the employer could get drawn into legal proceedings that they had nothing to do with. So those are some of the major concerns. When we're creating a policy, we want to create clear expectations and consequences within the framework that we've described. That can be a focus on, or that can be a ban on certain activities. It can be a ban of possession in the workplace. It can be a ban on intoxication in the workplace. A lot of times, those are the angles that we tend to look at as particularly valuable at controlling, because in terms of the use of cannabis, as Ryan mentioned, that can be tricky when you're talking about off-duty situations. But certainly the possession of and intoxication by at work are things that the employer absolutely can govern, and should set out clear expectation and consequences for that, that can result in discipline. The policy should likely use the word may a lot, and the reason for that is to give flexibility, right? This recreational cannabis use can arise in all sorts of different situations. It's important that the employer have the flexibility to be able to deal with things, and you want to have in that policy, you want to have trap doors for questions of addiction, for questions of medical marijuana use, so that way, when you're dealing with a marijuana policy that governs recreational use, you're not also catching up these potential human rights concerns, and treating them in a way that could unintentionally contravene the Human Rights Code. But we think it's important. So those are some general guidelines that we use. It's going to be very important for employers to consider how to address this, because if that policy does not come in place, there may be significant problems in terms of enforcing